dispense demain et après-demain.
Please, have a seat. Welcome back. This round will be for you to respond to the question. The question raised by the, now I'm addressing the applicant to reply to the issues raised by the respondent in the first round of oral submissions, as well as to the questions from the court. You have 30 minutes. Applicant.
Honorable, I was organizing my documents, so if I could hear whatever was said.
What?
I was organizing my documents.
Okay.
Yeah, so if you could repeat.
Okay. You need 5 minutes to organize? Because it's your turn. Or you are suggesting that I give the floor? Ah, okay.
Yes.
You did not understand what I said?
Yes.
Okay, okay. No, I said that is you have to reply to the issue raised by the respondent in the first round of oral submission before we suspended this hearing. But always as well as the question put by the court. Yeah. So you have 30 minutes for that.
Okay.
30 minutes. Okay.
The first point which the applicant wishes to respond. The first point which the applicant wishes to respond is in respect of the reference by the respondent to Article 129 Clause 4 of the Ghana Constitution, where the respondent contends that the Supreme Court of Ghana can assume the jurisdiction of a lower court in determining a matter pending before it. Yes, the response is, if you look at that article, the clause 4, it is when the matter is properly before the Supreme Court. In other words, if the Supreme Court is properly seized with jurisdiction, that it can apply Article 129, Clause 4. Now, the issue at hand is that the plaintiff, the private citizen, had gone to the Supreme Court to seek the interpretation or a determination on the constitutionality or otherwise of two stadia contracts. So the jurisdiction of the Supreme Court in that matter was to determine whether the contracts were constitutional or otherwise. The plaint by the applicant is that the Supreme Court, the review bench of the Supreme Court, went beyond their jurisdiction. They determined in effect and in substance the merits of the claim filed by the applicant. Now, particular reference to the concurring opinion of Justice Doche in the ordinary bench. Now, where he made specific reference to the fact that he had looked at two exhibits, one written by the applicant and another exhibit he referred to AG 17, written by Waterville, who were the second defendants in that case. And that if counsel had examined those documents, you would have realized that the applicant hearing, that he was the third defendant in that matter, had no case. The issue before you is to determine whether the contract is constitutional or otherwise, but not to determine the merits, whether he has a case or not. That is what was pending before the High Court. Then in the review decision, the Supreme Court again admitted that the High Court is the appropriate forum to determine the matter. Ordinary bench, the Supreme Court admitted that the High Court is the appropriate forum. Review bench, Supreme Court admitted that the High Court is the appropriate forum. But then it went ahead to say, at the review bench went ahead to say that if they leave the matter before the High Court, there is a danger that the High Court will come out with a conflicting decision. And therefore, it was truncating the proceedings pending before the High Court, denying the applicant the right to put his case across on the merits. And that was the end of that matter in the High Court. Now, the second point that I would want to respond to is on the exhaustion of local remedies. The respondent referred to the case in the Malawi case, Urban Mkandawire, and then Republic of Malawi. With respect, the facts of that case are not the same as the facts of this instant case. The respondent in his submissions indicated that the facts are similar to, they are diametrically opposite. Parallel. In the Malawi case, the Industrial Relations Court had ruled against the applicant for dismissal, wrongful dismissal. Now, the African court was of the view that the applicant was entitled to go before the High Court, one, or because he was dissatisfied, you could go before the High Court or a further appeal to the Supreme Court of Appeal of Malawi. So there were other courts up the hierarchy. And he did not go to those courts, therefore he failed to exhaust those local remedies, but came to this court. Now, in this instance, the violation of the human rights occurred on the review. That is the final. It didn't occur at the High Court. It didn't occur at the Court of Appeal. But the Supreme Court And one of the questions that we were asked, or which Honorable Justices asked us, is to define the judicial system of Ghana. And the judicial system of Ghana is, I would want to limit myself to the superior courts. It's the High Court, and then if you are dissatisfied with decisions of the High Court, you go to the Court of Appeal. If you are dissatisfied with the decision of the Court of Appeal, you go to the Supreme Court. Now, if you are dissatisfied with the Supreme Court's decision, that's the ordinary bench. You go to the ordinary bench first. If you are dissatisfied, then you apply for a review. And after that, that is the end. Meanwhile, the same constitution gives jurisdiction, what we call the supervisory jurisdiction, to the Supreme Court to supervise the High Court, so that where the High Court gives an order or makes a decision without any legal basis, patent on the face of it, then you can apply to the Supreme Court for judicial review, and the Supreme Court can quash that decision. But the High Court cannot purport to exercise any supervisory jurisdiction over the Supreme Court. So in an instance where the provisions of the law indicates that come and bring your human rights applications, violations before the High Court, and when you bring them before the High Court can issue orders including certiorari, prohibition, quo warranto, the prerogative rights, and so on and so forth. It cannot be possible against a Supreme Court decision, especially the review, which is the final. So the Malawian case can be distinguished from this instant case. It will interest Honorable Justices to note that in the criminal case which the applicant faced, the court took evidence from both the prosecution, 9 witnesses, and the applicant before arriving at its decision. And that decision exonerated the applicant of any wrongdoing, both 2 charges, fraud and causing financial loss. It is the contention of the applicant that if the Supreme Court had allowed the High Court to hear the matter, and one of the issues before the High Court was whether or not the applicant had a contract with the state to warrant payment of the amount that he received. That was one of the issues. That issue was not before the Supreme Court. The issue of whether or not, because this is also one of the questions which the applicant will have to respond, or which was asked a few minutes ago, that the issue before the High Court was whether or not the applicant had a contract with the state of Ghana. Before the Supreme Court, there was no issue raised. There was no issue raised as to whether or not the applicant had a contract with the state. Of course, that cannot be constitutional. It is for that reason why the ordinary bench, the lead judgment, indicated that that particular issue is not a constitutional issue. It doesn't call for any interpretation, and therefore, if the proper forum is the High Court, where the case is already pending. The respondent cited a local case, Nana Ajay Ampofu versus the Attorney General, and contended that that was a human rights matter which was determined by the Supreme Court. With all due respect, that matter was not a human rights matter. That matter was a constitutional matter the facts, he didn't indicate the facts, but the facts are that Nana Adjei Ampofo, who was a private citizen of Ghana and a lawyer by profession, went to court for a declaration that, excuse my language, night soil carriers, night soil carriers, yes. It's that business of carrying night soil in the night is against personal human dignity. It's unconstitutional, and therefore the authorities, the local assembly, should make sure that they halt that practice. That was a constitutional case. He did not go in respect of a human rights case. In fact, he didn't even have the capacity to pursue the case as a human rights case. Because if you read our Article 33(1), which the respondent has copiously referred this court to, the human rights must be directly directed at you. The human violation of human rights must be directed at you. So you, the person who has suffered the violation, is the person who must go to court. But the facts of the Nana Adjei Ampofo case, Nana Adjei Ampofo was not a night soil carrier. Nobody had violated his personal human dignity. He went to court to say that practice is unconstitutional. So the local assembly should put a stop to it. And the Supreme Court held that, yes, in this day and age, night soil carriers cannot operate in Accra or, for whatever matter, in the whole country. And therefore, it was unconstitutional and directed the assembly to put a halt to that practice. That is the Nana Adjei Ampofo case. Now, the respondent himself, in their submissions, they have referred this court to a case titled Eduse and the Attorney General, where they have contended that the Supreme Court held that in terms of human rights cases, go to the High Court. It's in their statement filed before the court, where the Supreme Court has ruled that if it is in respect of a human rights case, go before the High Court. And of course, the Article 130 of the Ghanaian Constitution indicates that the rights of the Supreme Court to interpret the Constitution or to enforce the Constitution, is subject to human rights provisions for which it is the High Court that has jurisdiction. So in that case, Eduse was asked to go to the High Court because the Supreme Court does not hear human rights violations. Well, his case was that his passport had been seized. His passport had been seized. And the Supreme Court held that, no, it is a human rights issue, so go to the High Court because we have no jurisdiction. So it has never been the case that the Supreme Court hears human rights actions. The Supreme Court can hear human rights actions only on final appeal, as indicated in Article 33, Clause 3. From the High Court, you move to the Court of Appeal. From the Court of Appeal, you move to the Supreme Court. If it's on appeal, but not as a court of first instance. And we have demonstrated that our complaint is against the review bench of the Supreme Court. So if we come to the High Court and we are dissatisfied, we go to the Court of Appeal and we are dissatisfied, where do we go? We have to go back to the Supreme Court, the very court that we are contending that their decision has violated our rights. That will be clearly against the rules of natural justice and will be an infringement of the Charter. It is our contention, again, that the judge who wrote the lead judgment in the ordinary bench, at the ordinary bench, Justice Lateba, has subsequently written a book criticizing the review decision of the review bench decision of the Supreme Court. And we have made available extracts of the book, the pages, to our statement of case. Because of time constraints, I cannot take the court through, but we have made it available, where he criticizes that the court has no jurisdiction, the Supreme Court has no jurisdiction to have ordered that the applicant refund the money, and that the High Court not to hear to stop or to cease hearing the matter. My Lord, again, the respondent on the issue of time made reference to other cases, and then to domestic legislation, that Ghanaian domestic legislation is keeping up with international standards and has limited the time to apply for human rights violations, bring actions against human rights violations to 6 months, in referred to Order 67 of the Ghanaian Rules of Court. With respect, rules, statutes, documents is a cardinal principle amongst all lawyers, that you read it as a whole and don't pick bits and pieces that will suit you and say that that is the position. I say so because if you read further, our Order 80 Rule 4 of the same legislation that he has referred to gives the court the power to grant an extension of time even when you are out of time. So the 6 months period that he talks about is not fixed. If you are out of the 6 months, you can apply for an extension of time. And if you are able to give a good and compelling reason, the court will grant extension of time for you to proceed. And the same principle should apply in this case. That once the applicant has been able to demonstrate a good and compelling reason in the interest of justice and fairness, he should be heard. This application must be heard. Now, with the questions that were asked, one of the questions was whether Justice Doche, apart from the great loot and share, which he did mention, whether there's any other evidence of bias. Now, our contention is that it is a chain. If you look at the ordinary bench decision, which has been exhibited before you by the respondent, we have also exhibited it. But if you look at the ordinary bench decision, now he's made particular references to, there were two concurring opinions, but for now we'll contend with that of Justice Doche, in which he says, with your permission, that for permission, this is indeed, counsel for the third defendant would have done himself a lot of good if he, whilst acting for the third defendant at the material time, had interrogated the issues thoroughly. He would have realized that his client was not entitled to what they claimed in the High Court and obtained.
Problème de traduction. Ah, okay. You are going too speed.
Too fast. No, I'm
fast,
reading.
Yeah. Even when reading. Okay.
Now, if I may take it again, it says, indeed, counsel for the third defendant would have done himself a lot of good if he, whilst acting for the third defendant at the material time, had interrogated the issues thoroughly, he would have realized that his client was not entitled to what they claimed in the High Court and obtained judgment for. Then he described the third defendant in the now infamous Woyome payment scandal. And then he concluded, under the circumstances of this case, there was absolutely no sound legal basis for the pursuit of the claims by the second and third defendants, Waterville Holdings and Alfred Agbes Woyome, respectively, against the government of Ghana. And then he says, once the matter is currently pending before other courts, namely the Financial Division of the High Court and the Commercial Court Accra, it is the expectation of this court that the principal actors in those cases will put up their best in the prosecution of those cases. Then, a few weeks after, there's a review. And with the review, it states, quote, as matters stand now, there is a real danger that a high court, which is the appropriate forum that this court referred to, may itself give a contrary and conflicting decision quite apart from what the court has given. Then, before then, he says again, indeed, if we stick to our decision in the ordinary bench, we would unwittingly have contributed to gross miscarriage of justice. This is because there is no guarantee that we can predict the outcome of the High Court decision. Then he goes on to say that if our decision in this review application leads to favorable decisions for the first respondent in the civil and criminal prosecutions, then so be it. This is at a time when the applicant was facing criminal prosecutions. And the Supreme Court says, so be it. To be put it bluntly means I don't care. So be it. In the context that it is used, means I don't care. And so with all this, we contend that the court had a prejudiced mind against the applicant. It started from the concurring opinion and ended at the review. I am hard pressed for time, so I don't know if I could request for a few more minutes and then.
5 minutes? 10 minutes? 10 minutes.
Well, 10 minutes. Yes, a question was asked on the court that is seized with jurisdiction to hear human rights violations. And our answer is by provisions of Article 33, 33 clause 1, clause 2, clause 3, and then Article 130 of the Ghana Constitution. It is for the enforcement of human rights. It is the High Court that has the sole jurisdiction to hear enforcement of human rights applications. Now, the follow-up question was, if yes, is it the sole reason why applicant did not go to the High Court? Because the answer is we've indicated that the violations emanate from the review decision of the Supreme Court, and it will be an exercise in futility. This is not conjecture. The provisions are there for all to see. It will be an exercise in futility that you go to the High Court and ask the High Court to declare a decision of the Supreme Court to be a violation of your human rights. Because the Supreme Court under the High Court under Article 129 Clause 3 is bound by the decision of the Supreme Court. Constitutionally, it's bound by the decision of the Supreme Court. So, by the hierarchy of courts, the High Court cannot question or determine the decision of the Supreme Court. Now, another question was asked whether we could tell the chronological order of applications that we have filed in the domestic courts, specifying the court switch action. There was a writ was filed by the applicant against the Attorney General and Minister of Finance. That was in 2010. And then for which the applicant made a claim. Now, the claim ended up in a default judgment, and the respondent compromised with the applicant, and then they filed a consent judgment based on which the applicant was paid the money. The money was paid premised on a consent judgment of the court, of the High Court. It was after payment of part of the amount that the respondent sought to set aside by instituting their own action in the High Court, which was pending. Now, another question was asked, if there was an action pending in the High Court, why didn't the applicant go to the High Court to complain about the violation of the human rights? With respect, as demonstrated this morning, the action that was pending before the High Court at all material times was filed by the respondent against the applicant, seeking to set aside the earlier consent judgment, as initially it said it had been obtained by mistake, and subsequently they amended and said it had been obtained by fraud. Now, there was no issue of human rights in that matter. And to invoke the human rights jurisdiction of the High Court requires an application and not a writ. So that is, the applicant couldn't have gone back to that case. In any case, by virtue of the review bench decision of the Supreme Court, that case that was pending in the High Court was truncated. It was truncated, so it was no longer pending. Now, on the issue of reparation, we were asked whether we have anything to substantiate or there's any evidence. Well, with respect, this morning we had a brief meeting, both parties and the president had a brief meeting, and we agreed that that issue will be looked at subsequently. And in any case, we filed our evidence on reparations, but it was filed belatedly. It was filed yesterday. And at the meeting this morning, the respondent indicated that they had not been served. So the consensus was that we'll look at it another time. They have to be served for them to respond, and then we'll look at it. And that is the reason why we were a bit silent on reparation this morning. Again, in the respondents' submissions, they indicated that the applicant was never detained. With respect, the applicant was detained by the court. First, he was arrested by the Economic Crimes Office, by the police, and then the Economic Crimes Office, and remanded in custody by the court, and subsequently was granted bail. So it is not completely true, with all respect. That is not a true reflection of the records, that the applicant was never detained. He was detained. Now, his properties, as we stand here, have all been attached. His all been attached. His assets, shares, and so on and so forth are all under attachment because of this particular decision. Now, what might interest the court is when the order for interim measures were served on the parties, as a result of which we went to the Supreme Court, because I've been asked the number of applications we made. We went to the Supreme Court to inform the Supreme Court by way of an application that there is an order for interim measures from this court. Now, the response of the Supreme Court, we have exhibited it by a ruling that they don't share their jurisdiction with any other body, international or otherwise, and therefore they are not bound by that order made by this court. And to all intents and purposes, they are not complying with the order for interim measures. Yes, they are not complying. The ruling is attached to one of our processes, the process that we filed, a ruling by the Supreme Court. Ruling by the Supreme Court, where we went to court to apply to arrest the ruling, to stay proceedings. Now, honorable justices would note that the respondent's supplementary statement of case on admissibility at the last 2 pages, or no, not the last 2 pages, Roman numeral 4, pendency of some actions filed by applicants in the Supreme Court of Ghana. Now, the respondents gracefully have listed those applications, and they have all been refused by the Supreme Court. The last one, that's number 4, the application to stay further execution proceedings pending the final determination of the matter before the African Court on Human and People's Rights. That one was also refused. And that is where the Supreme Court held that they don't share their jurisdiction with any issues of sovereignty and so on and so forth were raised. Now, finally, there was a question on the procurement process and the role of the applicant, the contract with the state. Now, the applicant's contention is that he is suing, or he sued based on a 2005 contract. In other words, his cause of action accrued in 2005, and not the 2006 two stadia contracts. Now, if you look at the decision of the High Court, that's the criminal matter, both the High Court and Court of Appeal, they have taken their time to review the whole situation on whether the applicant came to the court on the basis of the 2005 contract or on the basis of the 2006 contracts. And they were of the view, that's both the High Court and Court of Appeal, of the view that his cause of action accrued on the 2005 contracts where the government abruptly truncated or terminated the procurement process. Because by our procurement law, once you go through, it is ascertained, the bid is ascertained, and you go through the concurrent approval, the next step is mandatory, because the word used is shall. It shall, then of course, by operation of law, a contract is deemed to have been entered into, because it shall. But the government of the day truncated it, and therefore, that is the position of the, and we have again supplied the court with all these decisions. And then, on the lighter side, the respondent saying that it was because of a change in government that has brought the applicant here. That is not so. All the prosecutions and attachments and the arrests were all by the previous government. The new government came to power on the 7th of January 2017. So with all the materials before the court can make its own decision whether after 7th January 2017 the applicant has been prosecuted or he has been arrested or no. It is the previous government. So what the counsel for the respondent was saying cannot be true. It cannot be true. And before I resume my seat, I would want to raise a few issues with some of the language used by the respondent, especially in their submissions. They use the word illicit payments. This morning too, the word illicit payments. Payment that is pursuant to an order of a court cannot be illicit. Now, one of the provisions under Rule 40 is the use of temperate language. See, the language must be, there must be some, with respect, some decorum. But when you start using words like illicit and so on and so forth, trying to bring in, it's not acceptable. And by the rules of this court, Rule 40, it's not acceptable. So that is, I'll rest my...
Thank you, counsel of the applicant. I now give the floor to counsel of respondent. 30 minutes also.
Lordships, indeed. I don't know why my microphone is not working. Respectfully, still not working. Respectfully, we are grateful for the opportunity.
Okay, counsel, before you start, just want to inform you that you have 10 minutes, of course, if you want to use it.
Very grateful. Respectfully, we are grateful for the opportunity to respond. And indeed, we will answer the questions in the manner in which they were asked. Respectfully, the first question was for us to give a detailed and accurate chronology of facts.
Minute we... Yes.
Especially the first question was for the respondent to give a detailed chronology of facts, especially with regards to the procurement procedures and whatever. Especially we say that indeed the beginning of all of this was the award of the stadium contract. The award, respectively, I'm sorry, of the right to host the Cup of African Nations in 2008. That award was in 2004. The Confederation of African Football awarded the contract to Ghana, the right to host the tournament, to Ghana in 2004. Lordship, that clearly mandated that the respondent nation carries out activities to build new stadia and to rehabilitate the old ones. Lordship, so as we have filed before the court in Exhibit 2, attached to the original response of the respondent, the respondent requested various companies and joint venture companies to express interest in the building of new stadia. That is Exhibit AG2. It was 6 January 2005. Expression of interest. Especially, we say that under the procurement laws of Ghana, an expression of interest is not the beginning of procurement activity. It is not. It is only a request for companies to express their qualification in a procurement activity that will be undertaken later on. Lordship, indeed, many companies expressed interest pursuant to the newspaper publication, and then 12 tenders were written to, and that is in Exhibit AG4 and AG5. Exhibit AG4 shows a letter dated 8th June 2005, written to one of the 12 companies, and who in the scheme of this matter, in the circumstance of this matter, is very relevant. That is Vamed Engineering Company Limited. Lordship, Vamed Engineering Company Limited expressed interest and had been deemed to be qualified in terms of the basic qualifications to continue with any procurement activity. Especially, again, there was another letter written indeed in Exhibit AG5, the next Exhibit AG5, the requirement for those qualified to take part in the procurement exercise were spelled out by the Ministry of Youth and Sports. The Ministry of Youth and Sports indicated in the letter, which has been marked as Exhibit AG5, the relevant qualifications of persons who could undertake the procurement activity. The Lordship will note that in that letter, it was indicated that those persons had to show availability of funds from the lending institutions, the period within which the funds will be available, the detailed drawings, as well as a detailed program of works for construction. Also, and the reason why there was a need for a detailed indication as to the proof of funds was because it had earlier on been indicated in the original newspaper publication that the project was going to be a turnkey project. And respectively, by a turnkey project, it was understood that the qualifying companies, if selected, will carry out the construction themselves. The government of Ghana will not give money to them for them to undertake the construction. They have to carry out the construction out of their own funds. And then later on, payment will be made. Also, indeed, under a turnkey contract, the payment is made after there has been a due inspection of the project and there has been a proper handing over by the contractor. Lordship, this was indicated clearly in Exhibit AG2, the specific product and service to be carried out. It's all in the newspaper publication. Especially, indeed, after Vamed Engineering Company Limited wrote, expressing interest and after they had been qualified to undertake further procurement, and in accordance with the indications given by the Ministry of Education, they were supposed to provide a proof of funds. Your Lordship, it is very worthy to note that indeed Vamet Engineering Limited, as a matter of fact, indicated subsequently their inability to raise funds. Lordship, but before I get to that point, I would address the issue of the approval by the Central Tender Review Board. Oh, disturbing. Lordship, indeed, after the various companies had been shortlisted, the Ministry of Youth and Sports, which was the ministry carrying out the whole procurement exercise, wrote to the Public Procurement Board by a letter dated August 2005, requesting for the approval of the Central Tender Review Board to continue with the construction. My Lord, by Exhibit AG8, which is dated 5th August 2005, the Central Tender Review Board gave approval for the Ministry of Youth and Sports to continue with the procurement activity with Vamet Engineering Company Limited. Also, the letter is dated. Reference to letter number, the reference number is indicated. Dated 25th July, 2005. The Central Tender Review Board writes to give concurrent approval for the award of the contract to Messrs. Vamet Engineering, subject to your submission of the procurement plan for Ministry of Education and Sports, including that of the local organizing committee. Lordship, that is Exhibit AG8. Respectfully, indeed, the applicant makes a case that this grant of concurrent approval is a procurement contract. Respectfully, it is not. It is not, and it has never been under the laws of Ghana. And respectfully, I will submit that the relevant provisions of the Procurement Act in this connection, Lordship, are sections 20, 23, 30, 65. And my Lord will note that from the Procurement Act, a copy of which we have provided as Exhibit 3, Exhibit AG3. Section 20 talks about the role of the Central Tender Review Board. And Section 20 indicates Tender Review Board. There shall be established at each level of procurement the following tender review boards. A, Central Tender Review Board. Also, the functions are indicated in Section 20, Section 20, subsection 2. A tender review board shall perform the following functions. A, in relation to the particular procurement under consideration, review the activities at each step of the procurement cycle, leading to the selection of the lowest evaluated bid, best offer. B, subject to subsection 2A, give concurrent approval or otherwise to enable the procurement entity continue with the procurement process. Lordship, for this matter, with all respect, I deem this provision very relevant. Section 20, subsection 2, subsection paragraph B, which vests the procurement, the Central Tender Review Board, with the authority to grant concurrent approval for any procurement activity. And respectfully, it's indicated clearly that grant of concurrent approval is for the continuation of the procurement process and not a procurement contract at all. Especially, I submit that when a procurement contract comes into force or not, it's regulated clearly by the Procurement Act itself. And that is by the combined effect of Sections 30 and Section 65. Respectively, Section 30 says entry into force of the Procurement Contract. Especially if I may quote, it says, in tender proceedings, acceptance of the tender and entry into force of the procurement contract shall be carried out in accordance with Section 65 of this Act. And also know that when you go to Section 65, it says that a procurement contract comes into force once the procurement contract has been signed by the procurement entity and same has been dispatched to the person with whom the procurement contract is sought to be entered. My Lord, I may quote from section 65, subsection 1, a tender that has been ascertained to be the successful tender in accordance with this act shall be accepted. A notice of acceptance of the tender shall be given within 30 days. Then goes down to 65, subsection 5, says except as provided in subsection 2. The procurement contract in accordance with the terms and conditions of the accepted tender enters into force when the notice is dispatched to the supplier or contractor that submitted the tender, if it is dispatched while the tender is in force. So respectfully, it is only after a procurement contract has been signed and not when a concurrent approval has been given by the Central Tender Review Board that the procurement contract enters into force. Indeed, the grant of concurrent approval by the Central Tender Review Board is only at the beginning. It is only authorization for the procurement entity to proceed and enter into a procurement and carry out a procurement activity, which will culminate in the signing of a procurement contract. After the grant of concurrent approval, there are other processes spelled out in the law, provision for a tender to be carried out. If it is not a tender, it can even be single sourcing. That also has to meet the relevant provisions of the law. They are all indicated there. And indeed, the procurement entity is given authority by the law in section 29, subsection 1, to reject any proposal or quotation before the procurement contract enters into force. It says here, a procurement entity, section 29, subsection 1 of the Procurement Act. A procurement entity may reject tenders, proposals, and quotations at any time prior to acceptance if the grounds for the rejection are specified in the tender documents or in the request for documents, request for proposals or quotations. So, respectfully, after Vamet Engineering showed the inability to continue with the procurement contract as a result of their inability to raise funds, Lordship, what happened? Indeed, the procurement entity, that is the Ministry of Youth and Sports, on 22nd August 2005, wrote to Vamet Engineering, communicating the ministry's inability to continue with the tendering process. That is again Exhibit AG10. So in Exhibit AG10, the Ministry of Youth and Sports wrote to Vamet Company that we regret to inform you that the Ministry of Education and Sports, is unable to continue with the tendering process due to the high financial commitment implied in the submissions, the inconclusive and the non-assuring nature of the financial submissions. Really, what the Ministry of Youth, Education and Sports meant by the high financial commitment was that the Ministry of Education and Sports had indicated to Vamet Engineering its budget. The proposals by Vamet Engineering exceeded that budget. So apart from the failure to even raise funds, even their own proposals exceeded the budget to the Ministry of Education and Sports. For that matter, they wrote a letter dated 22nd August 2005 to terminate the contract, terminate the procurement process. At that time, there was no contract at all. No contract had been dispatched. Lordship, what did Vamet also do? Vamet also replied, accepting the termination. That is Exhibit AG11. It says, Vamet Engineering, that Vamet Engineering is a company which is active in the center of healthcare projects only and has no qualification or no interest in the award of contract for stadia projects. Lordship, then they continue that when it turned out that the envisaged financing could not be arranged, their financiers, VA Tech, withdrew from the stadia project, and Waterville, represented by Empower Park Limited, started to search for alternate financing possibilities with Vamet Engineering Limited. Consequently, we would like to inform you that Vamet Engineering is not and was never in the consortium of Waterville, and that therefore, in your opinion, this letter should have addressed Waterville. Furthermore, we would like to inform you that Vamet Engineering has not initiated and is not involved in the protest of Waterville's letter against the award. Most of the saying so. My Lord, and they also indicated that they are not interested clearly in paragraph 6. And really, the reason why Government Engineering was bringing a new company in, Waterville, was because unknown to the government of Ghana, and before the concurrent approval was given, government had assigned its right to Waterville Company. And respectfully, that assignment is indicated as Exhibit AG14. Although we note that Exhibit AG14 is dated 1st July 2005. It says, Government Engineering hereby assigns all of its rights and obligations in respect to the Stadia and Atomic Energy Project to Waterville Holding Limited. Government of Ghana was not a party to this. My Lord, the concurrent approval given by the Ministry of Youth and Sports was concurrent approval by the Central Tender Review Board for the Ministry of Youth and Sports to continue with their project. Respectfully, was dated subsequently. It was dated 5th August 2006. In the light of this, and with the time approaching for the tournament to be hosted, the government of Ghana then decided to, of course, if government has accepted the termination, then deal with Waterville to ascertain and find out if indeed they could satisfy the requirements for the construction of the stadium. All along, the applicant was not in. The applicant had never bidded for any contract. And indeed, there's no contract at all anywhere between the government of Ghana and the applicant. Especially, the government of Ghana then sought approval from the procurement board. Again, no, the first entered into an MOU with Waterville. That is Exhibit AG16. Exhibit AG16 shows an MOU entered into between the government of Ghana and Waterville. 17. Swiftly, it is Exhibit AG17. Especially, then pursuant to that, formally, the Ministry of Education and Sports applied to the procurement board for approval for Waterville to be single source, and that is Exhibit AG16. By virtue of this, 2 contracts were entered into with Waterville. Especially, I say 2 contracts, and it's most relevant because the court asked me whether indeed it was 1 contract we're talking about or 2 contracts. As far as we are concerned, it was 2 contracts that were entered into with Waterville Limited. The 2 contracts were for the rehabilitation of the Accra Stadium and the Kumasi Stadium. The applicant talks about 1 contract but has never been able to allude to any of them. Especially, these contracts are Exhibit AG17 and Exhibit AG17A. Contract with Waterville. Respectfully, that is actually what led to the situation. Lordship, again, Waterville was also unable to satisfy their obligations. They were also supposed to raise funds. They were not able to raise the funds. So, as at 1st August 2006, there had not been any funds raised by Waterville. And the Attorney General then wrote Exhibit AG18, bringing the fact that indeed all the conditions precedent for that contract had not been satisfied. And my Lord, the conditions precedent, apart from raising of funds, included parliamentary approval, because Waterville was a foreign company. So it is not the case that the government of Ghana hid from the relevant party, whatever, the need for parliamentary approval to be obtained. It's a constitutional requirement, and right from the beginning was made clear to whatever. The contract signed with them indicated so, that the contract became effective only after parliamentary approval had been obtained. Also, respectfully, that is why when Mr. Martin Amidou, the plaintiff in the constitutional matter, went to court that there was no parliamentary approval and therefore the contract had become ineffective, he was right, because it was a condition in the contract itself, apart from being a constitutional provision. The Attorney General wrote Exhibit AG 18 terminating the contract. Especially, Waterville also replied and accepted the termination. That is Exhibit AG 19. They said, we write to confirm that Waterville agrees that the contract relating to the above projects be terminated to enable the subcontractors to continue. Also, there were subcontractors that Waterville had entered into agreement with. So the government took the view that if the subcontractors had money to fulfill the agreement, and you, the main contractor, you did not have the funds, then let's terminate the contract with you and then deal with the subcontractors. Respectively, the subcontractors were Micheletti and Sons, as well as Consa. There were two Italian companies. They did not include the applicant. The applicant was never a company. He's an individual and never applied for anything at all. Lordship, then subsequently, Waterville came back with some claims that they had incurred some costs in preparation for the stadium contract and what have you. Especially, indeed, it was these claims which were later on compromised. Those claims were in 2009, after a new government had taken over. That's why it's relevant. It is not for the sake of bringing politics into this issue, but because the facts are so unwieldy. Anytime there's a new change, it's a change of government. Sometimes certain facts are lost on the incoming administration, and then they do certain things. Indeed, that's exactly what happened there. The government which awarded the contract was kicked out, with all respect, in 2008. A new government assumed power in 2009. Then all these problems emerged. The new government entered into negotiations with the applicant, first with Waterville Company Limited. Waterville wrote a letter making a claim for about 21.5 million euros. Then the applicant himself wrote a letter, Exhibit AG 23A, denying the claim of Waterville, saying that no, Waterville did not have the right to make the claim for 21 million, but rather he, the applicant, was entitled to 5 million euros, respectively, at that time. At that time, he didn't claim 51 million Ghana cedis, which at that time was 25 million euros. He claimed only 5 million euros. That's the letter by the applicant. That letter is Exhibit AG 22. Waterville and the applicant actually agreed subsequently. They agreed with each other, and that's Exhibit AG 23A. That indeed they were entitled altogether to a certain sum, 21 million euros. Subsequently, certain negotiations took place. But the fundamental point is that indeed this is the chronology of the facts, and all the facts would never show any participation by the applicant in the procurement process. And therefore, when the Supreme Court actually, after examining all these facts, arrived at the conclusion that Waterville and the applicant had actually colluded to make unlawful claims against, clearly they were justified. Lordship, I would quickly move on to address other issues raised by the court. And, my Lord, yes, my Lord, there was a question as to the PPA procedures, if I can indicate clearly. And, my Lord, I believe that that question has substantially answered, if I may move on. Then there was another question. How was the procedure started up to the instant case, up to the dispute? Lordship, I've indicated all the facts leading to the filing of the case. Lordship, so after the amount of 21.5 million euros had been paid to Waterville, the applicant then came up with a fresh claim of his own and filed a case in court against the government of Ghana. Lordship, that is the case in respect of which a judgment in default of defense, but the government failed to file a defense at that time. and the applicant obtained judgment. That is the case in which he obtained judgment before the defense was. And respectfully, the court will note that even that one, the claims were different. Initially, he filed a claim for an amount of 44 million euros. Subsequently, there was an amendment, and the plaintiff claimed amounts almost about 100 million euros. But these are all matters on record, Exhibit AG 33 to AG 34. Respectfully, the government of Ghana, after the judgment before defense had been entered against it, entered into settlement to pay the applicant. And respectfully, this settlement is indicated at Exhibit AG 34. They agreed to pay the sum in all 51 million Ghana cedis, which is why we are here. That's why, indeed, we say that he claimed the whole judgment debt, even though he was not entitled to, is that after the judgment of 51 million cedis was paid to him, certain facts emerged in the country. People raised hue and crew that indeed the applicant was not entitled to because he had never entered into any contract with the government of Ghana and therefore was not entitled to the sum of money. Then the government itself started to review the facts. Respectfully, upon a review of the facts, the government came to a conclusion on its own that the payment to the applicant was unjustified. And then the government of Ghana sought to apply to set aside the judgment of the court given in default of defense against it. Lordship, when this happened, they asked for a stay of execution of the judgment itself. The High Court, which gave the ruling, also ruled on a motion for stay of execution. That's Exhibit AG 35. The High Court dismissed the stay of execution, but made an order that instead of the whole judgment debt being paid to the applicant, only 17 million Ghana cedis should be paid. That's Exhibit AG 35. Lordship, strangely, the applicant, in violation of this court order, was paid the whole 51 million Ghana cedis by the same government which had applied for this. Respectfully, again, the government of Ghana, pursuant to the ruling on the stay of execution, decided then to apply by way of a fresh writ against the applicant because the court had made the observation that it was not entitled to come by a simple motion for stay of motion to set aside the judgment, but rather they should institute a fresh action alleging mistake and what have you. So the government then filed a new case, the Attorney General versus Alfred Woyome, Exhibit AG 36. And respectfully, this is a case which also led to the Supreme Court matter. And it's very important to that this case was not filed by the applicant. And therefore, when the applicant says that he should have been allowed to go and pursue his case at the High Court, he had no case at the High Court to pursue. It was rather a case by the government of Ghana against the applicant. The case the applicant himself filed had been concluded. That is the first one which resulted in the payment of the 51 million Ghana cedis to him. The government was then pursuing or taking steps to recover the unlawful payment from him. That is the second case which was pending. Then a private citizen, in exercise of his rights under Article 2 of the 1992 Constitution, Article 2 entitles a citizen of Ghana to file an action before the Supreme Court when it is considered that any act or any conduct of a person is unconstitutional. So the person, how many minutes? 10 minutes, bro. So the private citizen, Mr. Martin Amidou, filed an action pursuant to Article 2.1, Article 2, Clause 1, challenging the constitutionality of the stadium contract, the two stadium contracts government of Ghana had entered into with Waterville, and which had been terminated, and Waterville itself had even accepted the termination, but which the government of Ghana surprisingly had proceeded to make payments of about 25 million euros to it. And again, in respect of which same contract, the applicant had claimed the sum of about 51 million Ghana cedis from the government of Ghana. Respectfully, the Supreme Court, in exercise of its constitutional jurisdiction, it is so clear. Article 2.1 says a person who alleges that an act so may bring an action in the Supreme Court for a declaration to that effect. If a person alleges an action is unconstitutional, the person has a right to bring an action in the Supreme Court, Article 2, Clause 1. Article 131 also vests the Supreme Court of Ghana with sole jurisdiction in constitutional matters, except only when it comes to human rights matters. It's again the same Article 130, Clause 1. It says, subject to the jurisdiction of the High Court in the enforcement of fundamental human rights, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement of interpretation. So that is it. Then, indeed, respectfully, after the Supreme Court was seized of the matter by the private citizen, the Supreme Court heard the applicant fully, heard the attorney general. Even the attorney general at that time defended the payment to him. The attorney general, the state, actually, who was the first defendant, defended the constitutional action fully, filed submissions against the plaintiff in the case. But the Supreme Court came to a conclusion, with all respect, that the payment to the applicant, the stadium contract in the first place, was unconstitutional. But having come to that determination that the two stadium contracts were unconstitutional, then the Supreme Court took the view that because the applicant wasn't a party to that stadium contract, and there was another case pending at the High Court by the state against the applicant, that should be pursued. So the Supreme Court made an order for refund by Waterville, but the Supreme Court declined to make an order for refund by the applicant. Also, clearly, the plaintiff in that case found that to be unjustified, because if indeed it's the same contract in respect of which claims are being made by the applicant, and that is quite clear. The applicant, in the case that he filed, Alfred, Woyome, against the attorney general at the High Court, relied on the stadium contract in paragraphs 8, 9, 10, 11, 12, 13, 14, and 15. Then, so the plaintiff therein also filed an application for review. Also, we humbly submit that the application for review was properly filed because the Supreme Court has review jurisdiction under Article 132, and the review jurisdiction when it exercised properly. 133, the Supreme Court may review any decision made or given by it on such grounds and such conditions as may be prescribed by rules of court. The rules of court have also prescribed that where the terms of the case require miscarriage of justice and whatever. Clearly, also, and the reason why the Supreme Court indicated that indeed it could exercise the consequential authority to make such consequential reliefs, to order a refund of the monies by the applicant, was that, my lord, indeed, the plaintiff in the Supreme Court case was not a party to the case in the High Court. The case in the High Court was between the Attorney General, the state, who had made a payment to the applicant, and the applicant. Also, so clearly, it was a case where payment had been made by one person to another, and then they were fighting over the matter. And then a third party had challenged the constitutionality of the payment and had succeeded. So the Supreme Court took the view, not just because it couldn't control what was happening in the High Court, but because the plaintiff was not a party to the High Court case. And of course, as has been indicated, when it's exercising jurisdiction properly and review jurisdiction is proper, it can exercise the powers of any court vested in it. That is Article 129, Clause 4 of the Constitution. But see, then, well, there's a question as to if the Supreme Court erred in its judgment, the Supreme Court cannot share jurisdiction. I should explain respectfully. Respectfully, my explanation is that the question further was that, does it mean that the court cannot make a pronouncement on the facts of this case? Also, respectfully, the facts of this case properly, this case is a human rights matter. My lord will note that indeed, all the objections to the admissibility of the matter relate solely to admissibility. That is the fact that the local remedies had not been exhausted, and the fact that even if they were exhausted, the action was far way out of time. Lordship, the court indeed has jurisdiction in human rights matters. Our contention, respectfully, is that what went before the Supreme Court on the review matter was not a human rights matter. It was a review decision in respect of a constitutional matter. In respect, this court does not have concurrent powers in a constitutional matter with the Supreme Court of Ghana. It can exercise powers relating to enforcement of fundamental human rights, even in decisions from the Supreme Court of Ghana. that the court can do. Also, but we say respectfully that when it comes to interpretation of the Constitution, it is different from enforcement of fundamental human rights. That is why the same Constitution itself, even though it guarantees human rights, has clearly indicated that there's a distinction between enforcement of fundamental human rights and enforcement of the Constitution itself. Also, and that distinction is made clearer by Articles 2 of the 1992 Constitution and also Article 130. So the Supreme Court is given the sole powers, even in Ghana, in respect of constitutional matters. But when it comes to human rights, indeed the High Court can be seized of it, and it goes right up there. Also, the statement I made earlier on with all respect, that the court does not share, the Supreme Court cannot share its constitutional powers with this court. It's only within that context. It's only within the context of enforcing or applying the Constitution of Ghana. Also, but in terms of enforcing human rights, yes, respectfully, I agree that indeed the court has risen, but only after there has been an exhaustion of local remedies. Also, and I think that point can also be tied with the submission I made, which indeed we didn't even make any submission to the fact that the decision of this court cannot be enforced. Also, respectfully, Ghana has ratified the treaty. If I may respectfully take the opportunity to clarify, Ghana has ratified a treaty and the protocol to the establishment of the African Court in accordance with the constitutional provisions of Ghana. And the relevant provisions, with all respect, are Article 73 and Article 75. Article 73 says that the government of Ghana shall conduct its international affairs in consonance with the associated principles of public international law and diplomacy in the manner consistent with the national interests of Ghana. Also, clearly, Ghana's constitution recognizes respect for international law, and Ghana indeed abides by it. Ghana has ratified a number of treaties, and most of the time, Ghana is even the first country to ratify treaties. I can allude to the very recent African Free Trade Treaty, ratification of which I myself was present. The government of Ghana was the first country to move for it, and indeed now we have even ratified it subsequently in accordance with the laws of Ghana. Then Article 75, Clause 1 also says, Article 75, Clause 2, a treaty, agreement, or convention executed by under the authority of the President shall be subject to ratification by an act of Parliament or resolution of Parliament supported by the votes of more than half of the members of Parliament. This treaty has been ratified by Parliament of Ghana. It is not in doubt. That is why, as I indicated, we did not raise objections as to the jurisdiction of the court. The main, indeed, even though we titled our admissibility objection as jurisdiction in the original statement of case, the court will note that the arguments were in fact and in substance admissibility. So it is quite clear. The government of Ghana will not be. My learned friend refers to the decision of the Supreme Court of Ghana. No, that's the decision of the Supreme Court of Ghana. And really, with all respect, we didn't have any control over it. Safe to say that the court actually even made an observation that the orders of this honorable court were directed at the government of Ghana and not the Supreme Court. And the court will also note that since the orders were made, there has not been any enforcement proceedings at all against the applicant. The applicant throughout this year has never, apart from going to court for that ruling in January, he has never been to the Supreme Court again. And that is because the government of Ghana has decided to abide in the termination of this action. Respectfully, the applicant makes the point that his assets have been seized. His assets have been attached to execution. Well, that is a very strange contention. It is the same applicant who filed various processes before the Supreme Court, which are all pending, claiming that the properties do not belong to him. My Lord will note that when the respondent makes observation that he's actually engaged in a series of maneuvers just to avoid an enforcement of the Supreme Court judgment, it's quite clear. There are various processes still pending, which the government of Ghana has not pursued, awaiting this determination, by other persons other than the applicant, claiming properties that we know belong to him. As we stand before you, he's living in his own house. His wife is living in various properties in other parts of Accra. He claims that those properties don't belong to him. Nothing has been seized from him. So it clearly cannot be right that his properties have been seized from him and he's been put to a lot of trauma and torture and whatever. The court also asks the applicant to respond to the question that if the Supreme Let me quickly move on to. And it's also very important to note that even as we stand before you.
Counsel, time's out. You have 2 minutes
Very well, my Lord.
to
Lord,
conclude.
indeed, on the question of exhaustion of local remedies, it is very important. The applicant, even this year, filed a human rights action against the attorney general in respect to the same fact at the High Court in Accra. So the applicant is aware of the proper procedure to pursue human rights. Especially, he filed this action. We have attached it as part of the exhibit to our supplementary submissions on admissibility. He filed an action on 30th January 2018 after Woyome versus Economic and Organized Crimes Office and the Attorney General. My Lord will note that the matters that he has alluded to are all the same facts. He alludes in paragraphs 4, 5, right up down to paragraph 20, matters relating to the seizure contract. Also, this is an applicant who contends that there is no opportunity of a human rights enforcement regime in Ghana because the decision complained about was by the Supreme Court of Ghana. Yet, this year, after we had filed our submission of admissibility, then he goes to the High Court to file this action. The action is still pending, has not been determined. Lord, and again, it's also important, he complains about an arrest of him by the Economic and Organized Crimes Office. And that arrest was in 2005. And so when he seems to say that, oh, he's not bound by the 6 months and what have you, Lord, clearly, he himself, even, Lord, there's a lot of
No. Yes.
Lord, so when the applicant contends that because the Supreme Court had given a judgment and therefore he had nowhere to go, it cannot be right. He knows the proper procedure to pursue. That is the High Court. And then you come to the Supreme Court. I also contend respectfully that even if the High Court could not be resorted to by him, he could have applied to the same Supreme Court. The government of Ghana from 2014 to 2017 never heard about a single complaint of violation of human rights by the applicant against him. But the question I ask is that, is it fair, as a party which has signed up to this treaty and which also is bound by the requirement for a person to exhaust local remedies, to be taken by surprise about a violation of human rights for the very first time in this honorable court? I think that, with all respect, it defeats the object of the execution of the treaty. And he talks also...
It does not look like a conclusion. I ask you to conclude, please.
Because with all respect, the questions that were given to us were much more than the applicants. But I believe we had about 15 questions in all to answer. And that has made responding a little bit. And the very first question was very loaded because it talks about the history of the transaction. And that is actually a lot.
But you have also to manage your time.
Yes,
because if you spend
my duty to
10 or 20 minutes to respond
explain
to
the processes to the court. That is why, if I may just crave for about 10 minutes more.
No.
Very well, respectfully.
No.
But all you know, my Lord, the applicant again also waiting.
Okay, please, 3 minutes and we stop.
10 minutes.
3.
3. I'm very grateful.
Not 10. 3.
I'm very grateful.
Thank you.
I'm very grateful. My Lord, and there was a very important question as to the legal actions that can be referred for a constitutional review, and also who may apply to the court for Supreme Court for a constitutional review. My Lord, I understand that question to be what kind of cases can be sent to the Supreme Court on a constitutional matter or for constitutional determination. My Lord, Article 2, Clause 1 makes it quite clear. It says any act of a person or authority which is deemed to be unconstitutional, or any enactment, or anything done under the authority of an enactment which is deemed to be unconstitutional, can be sent to the Supreme Court on a constitutional matter. And then the question as to who can apply, it's any person at all. So, my Lord, even a foreigner in Ghana, if he deems an unconstitutionality being perpetrated against him, can apply to the Supreme Court for a declaration to that effect. And that is different from the High Court Jurisdiction. The High Court Jurisdiction, the enforcement of fundamental human rights, is in Article 33, which talks about recourse to human rights grievance. My Lord, there was also a question as to that in 2017, the High Court acquitted the applicant. Can you clarify whether the Supreme Court had previously convicted the applicant and then the High Court later acquitted the applicant? But respectfully, there was never a conviction of the applicant by any court at all. there was only one criminal case instituted in 2014.
In 2 words, because I will ask you to submit the oral,
Very well.
this oral submission by in writing.
Right.
So there is no need to expand.
Oh, very well.
To extend.
Well. Also, we've indicated all in our respondents' submissions on admissibility. The subsequent one we filed on admissibility. We've detailed all the cases, and we have indicated there was only one criminal case that was instituted against the applicant. Lord, and the judgment in that criminal case came after the Supreme Court judgment, and that acquitted the applicant. Indeed, the applicant, the state, appealed against that judgment to the Court of Appeal, and the state still lost. The applicant still walked free. And also, the relevance of this point is that it cannot be right for my friend to contend that once the Supreme Court has made a determination in exercise of its constitutional jurisdiction, no other court can make a finding to the contrary.
Thank you very much.
And
this will be your
indeed,
first.
All the other courts exercise different.
Because I have a follow-up question from the Vice President. And yes, Vice President, please.
Just very briefly, a follow-up question, very briefly. Considering that the Supreme Court review and even the ordinary bench, the issue was constitutionality of the contracts. Now, do you feel, or how would you show that the applicant was given his right to be heard before an order for refund was made? I'm focusing on the right to be heard before the court gave an order for refund.
Yes.
If you are to show how the applicant was given a right to be heard before that order was given.
Especially, that is clearly the case. The applicant, in accordance with the rules of the Supreme Court in the review matter, although the Supreme Court has rules set out in what is called Constitutional Instrument 16, CI 16. And that rules expatiate the exercise of the Supreme Court jurisdiction under Article 133 of the Constitution. And my Lord will note that, indeed, under CI 16, it makes provision for Rule 54 is on review, the procedures for review. And Rule 54 talks about the grounds for the review. Very briefly, yes. My Lord, yes, the applicant was given the opportunity to respond. Indeed, he responded to the application in writing. There was also the opportunity for oral hearing. He appeared before the Supreme Court for an oral hearing. All the parties appeared for the Supreme Court for oral hearing before the Supreme Court proceeded to give its judgment in the review application. My Lord, I respectfully submit that indeed this is in accord with the right to a fair hearing. The right to a fair hearing requires that the person be given an opportunity to be heard. This was the case. Right to be represented by a counsel of his choice. That was the case. The same counsel before you today filed submissions on behalf of the applicant. And my Lord, the judgment which we have exhibited on the review judgment shows all the processes filed. The applicant even raised objections, which were all ruled upon. So clearly there was a right to a hearing granted by the Supreme Court.
Thank you very much. And as I said, you have to submit everything in writings. And from today, 1 week.
1 week.
To both parties, of course. Both parties, 1 week. Also, with regard to the submission on reparations, I think you have been notified, I think. The respondent. Yeah.
Yes, my Lord, we
don't look at them because you are the one to respond to the application on the reparations.
Right. Okay. We'll do that. We'll respond to
so 30 days.
That's okay. So that's days. After we have been served.
You have not been served today?
Not at all.
Okay. After you have been served.
We're not even aware until
30 days for the reparation.
Very grateful.
Okay. Thank you very much, Counsel for applicants and Counsel for respondents. Oh, okay.
Yes,
applicants.
I was of the view that at least a brief response to the follow-up question will be appropriate.
Oh, yes, of course. Yes.
Yes. The
5 minutes, is it okay for the?
yes, 5 minutes.
Okay.
The application or the issue that was before the Supreme Court was for the determination of the constitutionality of the two stadia contracts. So that is what we channeled our energies to in response. Now, the complaint here is that the issue of whether the applicant had a contract with the government and as touching on the merits was not in issue. Now, our contention is if the Supreme Court had wanted to, knew it was going to rule on that, at least it should have given us opportunity to be heard before coming out with its decision.
Thank you, and that's what you will read. You will write in your submissions. Okay. Thank you very much, and thank you everybody. Thank you.
Very grateful.
For the government of Ghana, since
Yes. Yes.
at least the official representative of the government of Ghana here.
Yeah.
So may I express our sincere appreciation to you. The government of Ghana has had a very solid reputation in human rights enforcement and the commitment to the rule of law. And we have been very appreciative of the opportunity to contribute to the development of the coursework. On that basis, we thank you and wish you all the best.
Thank you. Thank you very much, and safe trip for your return.
Very